Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. Today's episode of Elawvate is brought to you by the Expert Institute. Rahul, you guys use Expert Institute, right?
We do use Expert Institute, and it's fantastic to get different experts in different fields, but the best of the best. And you don't know until you do the research, and they do that all for us.
Today's show is also brought to you by Filevine. Filevine has a platform called Lead Docket, which is the state-of-the-art way of tracking all of your intakes and leads, particularly if you're putting money into advertising. You don't want to waste money by missing a lead or missing a good case. It also doesn't mess up your case management software by keeping it in a different platform just focused on your leads. So check out Lead Docket by Filevine. Also brought to you today by Steno. Steno is a product you've used a lot, Rahul, right?
Steno is fantastic as a court reporting company. In addition to that, if you haven't tried Transcript Genius, it is an AI-based search engine where you can ask it questions such as, with an entire case, all the evidence on negligence, and it'll pull all the deposition testimony from all of the witnesses and put it together in a seamless way with hyperlinks to the actual text. Amazing.
And if your state law allows it, you can also defer the cost of depositions till the end of the case, which is, we were just going through our budget, and transcripts from depositions is in the top 5 of our expense items. So it's worth checking that out. Our show's also brought to you by Smart Advocate. That's the case management software we use at our firm. Our staff loves it. We love it. Very intuitive, very robust, can be adapted to do a lot of different things from mass torts down to small PI firms. So take a look at that. Finally, Hype Legal is the firm that we use for our social media and for our website design and development. We just rolled out our new website about 2 months ago that was designed by Micah and Tyler at Hype Legal. We love it. We've had a lot of great response to it. So if you want to see their work, come to our site at gideonason.com. And if you like what you see, contact Hype Legal and see if they could do the same for you.
Welcome to the Elawvate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon. How are things, Rahul?
Things are great over here, Ben.
So your partner, Brian, got a nice verdict, I saw.
He did, and then he locked in a even better high-low before the verdict was read. So it was a horrific injury to the leg of a really nice man down in San Diego. Case went to trial on the issue of the defendant driver was driving 104 miles to his workplace. And usually that's not the course and scope of employment, going and coming from work. But there's a number of exceptions, some of them being the required vehicle exception, special errand, special mission. And so the defendant employer was fighting that issue tooth and nail. And closing argument, finally, the defendant, who offered $1.5 million before trial, offered $37 million. And then they locked in a high low of 30. That's a pretty big jump. Yeah.
Yeah.
And then and then they locked in a high low of 37.45. And then the verdict, about 5 minutes before the verdict was read, and then the verdict came in at 27 and some change. So now they're getting paid in 30 days for a little over 37 million.
Well,
Sounds good.
that's we like to hear California stories just to set us all straight, you know, in the rest of the country where it doesn't always work out just like that.
But there was at kind of the same time, you remember I talked about at the last meeting that jujitsu trial I had down in San Diego, which was up on appeal, and then the Court of Appeal affirmed the decision, and then they took it up to the California Supreme Court, who denied review, and so the $46 million verdict they just paid last week my client $56 million. So
Wow.
that got done too. So we got some
So
good law published opinions here, and a great outcome for my client.
that's fantastic. No, great results. So it sounds like the lawyers at PSR will manage to be able to eke by another month in the world of living paycheck to paycheck. So congratulations there, Rahul. No, that's great. Interestingly, we just hired a new marketing director at our firm who's a very skilled practitioner of Brazilian Jiu-Jitsu, and he was very interested in your verdict. And we've had a lot of discussions about it, and he's some strong opinions. But anyway, yeah. But he was incredibly impressed that you got Gracie, whatever his name is,
he's
to
Henry
testify.
Gracie.
Yeah, I mean that's
So
just
much
like
fun.
a major coup. So speaking of Brazilian Jiu-Jitsu, we're very pleased to welcome Dennis Donnelly to the show today. He's sort of the Brazilian Jiu-Jitsu of trial lawyers. He implements Jiu-Jitsu tactics, but in the courtroom. Which we'll get to in a moment. But one of my favorite facts about Dennis is that in addition to his home in New Jersey, he also has a place kind of right down the road from me in Maine. So it's nice. He comes up in the summer. He's been kind enough to come over and visit. So it's I consider him a fellow Mainer. So welcome, Dennis, to the podcast.
Thank you, Ben. Thank you, Rahul. So I gather that you start these things by talking a little bit about your background. And before I do that, it was very nice of the two of you to establish by California verdict standards that any verdict amount I'm going to mention in a New Jersey case will seem, like not so much. But every state, the odd thing about legal practice that I've learned, one of the things I've learned in 44 years, is that the oddest thing about legal practice, which we all know, but experts don't know, and I shouldn't say we all know because some do and some don't, is that it's different in every single state and particularly procedurally. So we don't have real voir dire in New Jersey. That's not a good thing. We have a judge, who asks a few questions. We're working on it. We get a little bit better, but it's nothing like most other states. We're not allowed to give a number to the jury. So we can't do that, and that kind of hurts. We're not allowed to talk to the jury after verdicts to find out why they did this and why they did that. On the other hand, even though New Jersey's right across the Hudson River from New York City, which has its own little quirks in practice, we don't get the verdicts, the amounts in verdicts that they get in New York City. But on the other hand, our appellate division tends not to take away verdicts or reduce verdicts the way they do in New York. So every place has pluses and minuses. But let me say a little bit about me. I've been a trial lawyer for 44 years, only for the plaintiffs. Through an odd sequence of events, I once defended a case, I will confess to this, because somebody I went to law school with changed firms, etc. And there was a claim against a space heater manufacturer for a law firm fire in June, when in all probability the space heater wasn't even on. So, and the case was all about property damage and not people who got killed. So I didn't feel too guilty taking the case. I took the case. I tried the case to a no cause. And my wife kept saying to me, "Are you sure you're on trial?" I said, yeah, I'm the defendant. I just get to listen to what the people say. And then it's much easier, to not have to prove something all on your own case. And I don't even have to line up all the people ahead of time. She said, okay. But I said, I would never do it if people were hurt. And I would never, I would not make as much money, I think. But in any event, so I was one of 6 Irish American kids. My brother and I were the first to go to college. I then graduated from college and said, oh, this is good. So I continued on the way to becoming a university English professor. I completed my master's in a year. I completed all my PhD work and was all the way up to the dissertation. And then I got married. And at the same time, I was going to conferences where people said the job market for real tenure track English teaching positions will probably improve at the turn of the century, 23 years from now. So I said, well, what are we supposed to do? In the meantime, people were traveling on 1-year non-renewable, non-tenure track jobs. So I loved teaching. I would have done that if, I got a real job as opposed to being an adjunct in 5 different places with no office and no benefits. But instead, I decided, with a lot of help from my wife, to go to law school. And she insisted that I would make a good lawyer because she heard me talk about books that she knows I didn't really completely read, and it sounded good. So that was a good instinct. And she also agreed to work 2 jobs while I went to law school. And we're still married today. So that's a little bit of my background. I will just add before we go into specifics that I think that, people ask in college, well, what's a good, field, to be for lawyers. And some people say political science, whatever they say. Lawyers, are all about words, spoken words and written words. So it's not bad preparation, to have actually read a lot of books and, know about literature and know about ideas. So there's that. So let me say one more thing about background to sort of highlight what I'm going to talk about a little bit. 20 years ago in practice, people used to go to seminars and they used to talk about, what are the killer questions on cross-examination, or, they would talk about pretty narrow techniques and limited techniques. But then people like Rick Friedman and Don Keenan and many others came along and they said, well, wait a minute, you guys, isn't it more important for you trial lawyers who are trying to tell a story to 8 people in New Jersey? We can have 8 rather than 12. You drag off the street, you're not going to connect with them with law school talk and with what you learn in law school. So the sea change was that all of a sudden lawyers, like in the inner circle, were talking about neuroscience, and how people and juror biases and framing, et cetera, and anchoring, and you name it. And it's gone on and on. And for those who are listening to the podcast, and I'm going to talk a fair bit about medical malpractice cases, the books by Rick Friedman and Pat Malone, the rules of the road for medical malpractice cases are very good. And actually, there's a few things that I told them about and got in that book. So let's talk about what we do. And it's really an interesting profession because, number one, in every trial, one side wins and the other side loses. So, it's not like, you can settle a case or you can have a high-low, but it's a pretty high-stakes job to start with. Number two, no matter how good you are, no matter how hard you worked, you can't testify. So you have to put other people up there who hopefully, you've learned to understand their pluses and minuses and how to present them and when to present them. And to a large extent, for example, when one of your experts tanks, or when one of your plaintiffs tanks or a witness tanks, you've really got to manipulate things and work on your feet. A good motto for lawyers, trial lawyers, is that they have to become collaborators with chance. And that's something that Edgar Allan Poe said years ago, about good thinkers. We really deal with constant possible, interruptions, emergencies, you name it. So we have to be able to do that and to fit it within the case that we're trying. So to start with, where you start, Jim McElhaney used to write an article about litigation in Litigation Magazine. He was a law professor and a lawyer in Chicago somewhere. And he had a lot of good things to say. And he once said, lawyers in law school learn to recite facts to fit within a cause of action. And when you think about it, we do. Initially, you have to learn, what do you have to prove so that someone was negligent? In a malpractice case, you have to have, an opinion. Do you need an opinion from of the same board certification, et cetera, et cetera? So we're trained that way. But he said, jurors, they want to know why something happened. Why did this? And I've had rote defense lawyers get up on openings in malpractice cases and say, well, my doctor is board certified and he went to school for 15 years and the plaintiff says he made a stupid mistake, as if those two things are contrary. So you really have to get beneath the sort of simple, what were the facts? There was a story that people used to tell. I think it was E.M. Forster who once wrote, if someone tells you the queen died and then the king died, or the other way around, the king died and then the queen died, that's not a story. It's just two separate facts. If they tell you the queen died and then the king died, now it's a story because the two things are causally related and they fit together. So what we're always doing in these cases, first of all, at least, is to sort of consider, what's the backstory? Why did this happen? And I don't know about all of you, but I try a lot of cases, and usually somewhere in the trial, maybe it's too late, I tell myself, this is why this happened. But it takes a while to get there. And if you can get the jury there and lead them there, and it doesn't. So, for example,
Dennis, could I just cut in and ask you a question about something you said? So one of the things that you alluded to is that, we're not allowed to testify. I mean, there's a lot of times when I know exactly what I need and want my expert to say, and I could articulate it very clearly and concisely and in a compelling way, and they get up there and, as you say, it's very difficult to control. What is your process to prep your witnesses, your doctor witnesses in a medical case?
Good point. So first of all, again, getting back to the different rules in different jurisdictions, the most important thing a lawyer can know, and this is harder for lawyers who practice in multiple jurisdictions, is what's discoverable from my prep of my expert witness and what's not. Although we have a lot of bad law in New Jersey, we have good law on that. It's the so-called safe harbor rule. Although we have full-style expert reports, in some sense, that's good because I can collaborate. Let's just use a fancy word. I can collaborate with my expert in the writing of their report. Now,
and that's not discoverable.
And it's not discoverable. The only thing that is discoverable is his final report, and I have to prep him to say, yeah, and I relied on my own training and the records. I don't listen to what lawyers tell me, something like that. But
can I ask a question about that? Because something that's come up recently in our practice, which is sometimes we will record our prep meetings with the experts because now we do most of them on Zoom, and you have the capability. First of all, if there's radiology or if they're showing us something that we want to be able to remember, we might record it for our own purposes so we can look at it later. But sometimes we've elected not to do that on the fear that could someday become discoverable. But I feel like as more and more people are prepping online and using AI functions to record or to summarize, both sides will probably be doing that. But what is your view as to whether that would be discoverable?
Okay,
And
well,
I'm curious about Rahul, whether you guys do that too, and
okay,
what your issue
so
is.
in New Jersey, more likely than not, it wouldn't be discoverable because the rule is there was a really great trial judge who was a friend of mine who passed away, Chuck Walsh. And he was actually a defense lawyer in a products liability firm. And when they were considering this rule, he said, look, it's foolish to think that lawyers don't interact with their experts and that they don't know a lot more about the case than their experts. And to have them do things like, oh, we can only talk on the phone, or, I didn't say this, but, it's just foolish and wrong, and it's just a charade. So let them do whatever the heck they want to do. Let them partially write the report, but the expert then has to essentially sign the report and certify the report, and that's what's discoverable. So if your jurisdiction has law like that, what's the difference between videotaping, the prep and whatever? The thing is, though, that this getting back to witnesses, and I think trial lawyers like the three of us who have been trial lawyers for a long time recognize that every witness, is a potential godsend or disaster. I mean, or a little bit of both. So you then have to make sure to remind your expert witness, by the way, don't go saying at your deposition, because we do have expert depositions, oh, yeah, I went through all this with my lawyers on Zoom and we videotaped it, or something like that. In fact, I don't know if you tell them, although now Zoom got religion and it sort of comes on the screen and says this session is being recorded. I don't know if you can get around that, but I would prefer your expert not to know so they can't inadvertently slip and say, I recorded this. But if you can do it that way, I'm absolutely with you. We're all fallible. We can't necessarily remember something we talked to someone about 6 months ago. And the problem with post-COVID lag in trials is that more and more we're preparing for a trial and then it goes off. I don't know about your two states. You can comment on this. We're preparing again and it goes off. So you have to have some way of preserving all that preparation. And, video and whatever is sometimes a good way to do that. So I think it's a good tool. The other thing is, and I've often said this in talks, expert work is your expert's nighttime job. It's not his day job or not her day job. So, they don't always know the rules of the road. And so you not only have to educate them sometimes about the case facts, you have to educate them a little bit about, we can exchange writings or we can't. Yes, even though I tell you a lot of things, your final opinion is based on, your training and your review of the case. So it's like everything else. There's a lot of preparation we need to do. And let's talk for a minute about the plaintiffs, because I think that illustrates another change in trial practice in my 44 years. 20 years or more ago, we all were under the delusion that all we needed was a really sympathetic plaintiff, and jurors were very empathetic. And if we just, a lot of lawyers, journeyman lawyers would say, I just put the plaintiff up there and, the case is over. Well, frankly, no, the case is probably over for you. We can all disagree. We all have different opinions. But I think in the last 20 years, everyone has moved their damage witnesses and their plaintiffs further and further back in the trial. And I'm going to discuss for a minute, I think, a couple of neuroscience reasons for that. One of them is this. Modern day jurors are skeptical people. Everybody's skeptical today. They're on the internet, this is wrong. Everybody has a lot of skepticism, but they only have so much room in their head to hold their skepticism. So you put your plaintiff on first, they're raring to go. They say, what do you mean? Why didn't you get a second opinion? I don't believe them. They don't seem credible. All kinds of judgments they're going to make early in the case. However, if instead as in most malpractice cases I do, you put the defendant, particularly only where it's a bad defendant. If it's a really great defendant and he or she presents really well, I'm not going to throw him up there first in the case. But if it's the typical, one of the godsends of medical malpractice trial law in New Jersey is that we often get, not so well trained doctors and people who aren't really that impressive when they talk. And of course, we take a deposition and we film them. So, and that leads to another topic: the easy availability of videotaping discovery depositions of the defendant. And even if it wasn't easily available, you still hire a videographer and go through the whole shooting match. Really adds a tremendous component of trial practice that you can use in many, many different ways, which is this. You take the deposition, you see where the defendant treater says, bad things, good things for you, or just where he looks or she looks, kind of callous and could care less. And you create video clips, and some judges will let you use them on your opening. Almost all judges will let you use them independently of necessarily having that witness on the stand. And I've done this in several trials, and the defense lawyers say, well, the plaintiff's lawyer has to make a choice. He's going to play these videotapes of my witness, and he's going to cross-examine him and call him on his case. And the judge says, yeah, because he can do that. It's an admission. And the most valuable videotape depositions are of the defendant because you can use them. The least valuable videotape depositions oftentimes are of experts because, it's much harder to use them, but, still you can do it and you use them well.
Dennis, I had a question.
Sure.
So I'd love the way you summarized sort of the why you choose the order of witnesses and the plaintiff going later, and the sort of the skepticism and the amount of volume somebody has.
Mm-hmm.
How do you make sure that skepticism doesn't come back against the plaintiff in the cases you try?
Okay.
As your in your case in chief? And
it's a perfect question, and I talk a lot, so it's good when somebody feeds me a different line. It slows me down a little bit. I don't want to talk too much, so I have a lot to say. And all right, so it's an excellent question, and it's always a risk. But if you talk about the mental capacity of jurors, they only have so much body inside each brain to hold their skeptical thoughts. And if they get really exercised early on the defendant doctor, either by calling the defendant doctor or by calling a really good liability expert who kind of lays it all out, here's where they went wrong, they're much less likely to also turn around and be skeptical about your client. But there's two more things at least that I always try to do, and I think help with that. Number one, on opening, I typically have a tendency to say two things. I say, well, look, there's catastrophic damages in this case. You're going to hear all about that from numerous witnesses. But I haven't earned the right for me to give you all my opinions about how devastating and how catastrophic they are. And I'm pretty confident, as you listen to the evidence, I won't need to. But if I do, I'll do it on summation. Okay, so to give them a roadmap. I think that's helpful. The other thing I've done, okay, and the two biggest verdicts I've gotten in New Jersey in the last 7 years, both 8-figure verdicts, is to make an evaluation of how much would it help me or hurt me to actually have the injured plaintiff in the courtroom at all. Okay. And the great thing about being a plaintiff's lawyer is we get to make these global decisions without having a committee and an adjuster saying, why'd you do that? So in both those cases, I never brought the client into court. In one of them, it was a baby who was so injured that I kind of was afraid that I might wind up, causing her death. having people drag her into court. But more importantly, and this is important for the preparation, I had video of her at school, her school, with people walking her around in a wheelchair she could direct by touch to go left or right, and video of her father in his daily routine of preparing all of the things that he had to give her, and more or less force down her throat. And, what else do you need? I mean, and so you can let them see it rather than saying it. In the last case that I am going to talk a little bit about, but, who knows how much time we have. It was a case about a state trooper who responded to an accident scene and was idiotic enough to conclude that a woman with every possible sign of a stroke was instead on drugs or alcohol, and she needed to arrest her and drag her far away to a station and handcuff her and do all kinds of ridiculous things. So it was a powerful case. And again, because of Zoom, I found, I don't know about you guys, and you can chime in here, some defense lawyers now are having their so-called independent, exam by a neutral doctor, of course not, on video. And because, their guys don't want to travel here either. And then they have their life care planner on, and I get my life care planner on, and everybody gets to watch the exam. So in that case, we had me filming the plaintiff within a year or two of the incident, when she still couldn't say a complete sentence. She could only say isolated words. And with a speech therapist, thank God they let us in. My life care planner was there, so then she could use that as a material that she relied on. And it was painful to watch. She was just, and the other thing about it was that the victim, the plaintiff, had a tremendously nice manner about her, even though she was in a terribly frustrating position. She would apologize to the speech therapist and hit the side of her head and say, the word is inside, as if she was trying to knock it out of her head so that it would come into her mouth and she would be able to say it. So, I mean, that was powerful. We then had an exam by my neurologist 2 years later on video. And then we had another exam by the defense neurologist a couple of years later on video. So we had 3 videos clearly showing to the jury, how bad the situation was. So the line I tend to use on opening about this is I say, look, Kylie Tapia or Cheryl Rhines have their own dignity. And it would be embarrassing to them and possibly even harmful to them to bring them in here and have them face the 8 of you people who they don't know and have you see what they can't do and what their lives are like. So I'm not going to insult their dignity, and I'm not going to insult your dignity, but I'm going to show you what you would see. And I hope you don't feel that, you would have been more sympathetic if I had brought them into court, because, this is so catastrophic. You'll see it. It'll be obvious. And that's why I'm telling you now, I won't. And then I had the neurologist testify in the state trooper case that not only would it have been embarrassing for the person with global aphasia, inability to speak combined words, it might have been actually damaging in a psychological way. So I think the jury, in the old days, before you really thought about these things, you might have people in court and have a life care planner saying how terrible their life is going to be. So years and years ago, I realized, I walked down, I let the jury see that I walked down and tell the life care planner to leave, or not, or certainly walk down and tell the sisters and the mother and everybody else to leave, because why should they have to listen to this? They live with this every day. So, I mean, I think all of those things are helping us. But, many times we have witnesses who are terrible witnesses, and we have to try to find an excuse maybe for not even calling them. The husband, I have a death case for a Portuguese woman, and the husband, doesn't know a lot about anything and doesn't present well. And, so why call them? The daughter and the son, speak very well about that and, really, really help us. So I think, sure, skepticism is always an issue, but by structuring your witnesses and by the order in which you present your witnesses and by the way you introduce the topic, I think you go a long way towards defeating the skepticism. And I think that has worked. Let me say a little bit about experts, by the way, because I've mentioned them. And it's always astounding to me when I talk and I, give lectures or speak at seminars, afterwards, after I talk about a case that went remarkably well because of a lot of effort, because of all these different steps, sequencing witnesses, thinking of how best to present, demonstrative evidence, the whole panoply of things we do, and you get a good result, a lawyer walks up to you, and that lawyer, is sort of a general practice lawyer, and they ask you the question that lawyers like the three of us probably dislike the most, which was, well, who was your expert? Who was your liability expert? Because they firmly believe that if they get the same expert and they just put them on the stand and let them talk, they'll do great. Well, we know that's just not the case. We have to be actively involved in helping our experts understand the case. And we have to, within the limits of what we can share with them without being discoverable, have to help them prepare what is essentially the theme of the case. While I'm on that, there's, as I say, juries want to know why something went wrong. And if you're trying a malpractice case and you're unable to explain to the jury why an otherwise intelligent human being made a stupid, idiotic mistake, if you don't do it, how do you expect the jurors to do it? The ones who are on your side, the other ones will say, well, how do we know what was going on? Blah, blah, blah. So you really have to deal with that and give them a frame. And the frame can be, yeah, he has a 200-page CV and he writes all kinds of articles, but he never listened to the patient and he doesn't care about people. Or he's so impressed with himself that he never bothered to read the nursing note, the hardworking nurse's notes. So that gives them a reason. They say, yeah, we know people like that. We work with, sometimes I'll talk about, you probably work with people who Donald Trump would be the perfect example, who doesn't read the briefing every day, who don't know a lot, but, sometimes act as if they did. So, I think that's all helpful. I had one other thought. It just kind of jumped out of my head. Okay, so anyway, that's one of the things I think jurors want to know. And that's why, as I said before, the ordering of witnesses, the use of experts. Let's throw this out to the three of us here. I used to be terribly afraid of having witnesses on videotape as opposed to live in court. Okay? It's, we all think it's just not the same. On the other hand, there are a lot of people on jurors today who are really used to looking at people on TV screens telling them what to do and what to think. So maybe it's not as catastrophic as we think it is. And surely if I had a couple of witnesses on the same topic, or, I wouldn't be as anxious about doing, and you can do it real time, but it's still on video. So I guess the advantage of doing it before trial on video, if you have multiple witnesses, is if it doesn't go well, at least in New Jersey, you don't have to use it and they can't comment on it. You don't vouch for your experts. So that may be another reason why you might want to have two experts on the same issue. And we do have good law there that, it's not an accurate objection or a sustainable objection to say, oh, well, it's cumulative. You can always have them do something else. The other issue, and again, I'll allow the two of you to maybe talk about different jurisdictional rules. Physicians, were smart, and their insurance carriers were smart, and they created these witness qualifications rules for malpractice cases that a person has to have the same specialty and be board certified in the same specialty as a defendant, because that's the only way they would really know, what the right standard of care is. We have that in Jersey, but only for doctors. But it doesn't apply to causation. It only applies to liability testimony. So, and you have to carefully parse your own court rule. But if it doesn't apply to causation, you can use retired, doctors who still teach, who are great teachers, on causation. And most of the time, what they're going to testify about on causation bleeds back into liability in any event. So, I think that's a good tactic. I talked a lot about malpractice cases, medical malpractice cases, because years ago, lawyers said, well, those are good cases because, doctors have lots of coverage. Sometimes yes, sometimes no. Poor Rahul practices in a state where, they sabotage the attorney's fee in malpractice cases. So that's another reason, not to do them. But generally, you start out at a slight disadvantage in a malpractice case. Most people kind of assume, well, doctors sort of kind of know what they're talking about, and you have to work against that. And you have to either make this doctor or doctors outliers, because there's a real danger in the shotgun defendant approach, which some less experienced lawyers use. They say, okay, I'm going to sue everybody and, I'll work it all out. And there'll be more people contributing to settlement. Well, first of all, doctors have consent policies, and most of the time they don't consent to settlement anyway. So that's not true. Secondly, each doctor, unless, as sometimes happens, the carriers are cutting corners, tends to get their own lawyer. So you got 5 defense lawyers and you. And in New Jersey, we have a horribly unfair practice that each defendant gets 6 peremptory challenges, but the plaintiff only gets 6 total. So if you got, 5 defendants, they have 30 challenges and you have 6. Judges have some leeway in giving you more, and sometimes the judge will say, I'll give you 4 more or something. They don't understand the mechanics. Because when you think about it, peremptory challenges are like nuclear weapons. If both sides have the same number of peremptory challenges, they're less likely to use all of them because they know the other side can keep throwing people off. It would actually, so judges think it would slow down jury selection. It actually might speed up jury selection. And
how does that work in New Jersey, though? I mean, you don't get to do any voir dire.
Well, the judge does. Yeah, the judge does, voir dire, oh, you can be fair. And then the judge will say things like, oh, well, you can be fair anyway, even though, that kind of stuff. And some judges will you can always submit questions. They'll ask some of the questions. They'll water down some of the questions. And the way it works then is that based on that limited voir dire, you then get to exercise peremptory challenges without directly questioning the witnesses, without, most times the most revealing answer you get is, what's your primary source of news? They always ask that. That's part of a set of form questions because, some people say Fox News and other people say NPR, something like that. I had a case once where a guy said Al Jazeera, and everybody in the jury looked around. This was like, 8 years ago, when we had Osama bin Laden and the whole deal, and that was kind of startling. I think he stayed on the jury because I decided, so what?
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. PSRplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRPlaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRPlaybook.com and learn from the best.
At least
But-
it wasn't Alex Jones.
It wasn't Alex Jones, exactly. Yeah, I know. Well, so you get people who say that. In the police case, I had a witness at sidebar, and he started going off about the good guys with guns, and you knew he was a short-lived person, on that jury. Because and look, there is a certain amount of bias up front in medical malpractice cases, in cases against the police. I don't know about corporations anymore. That's been bouncing around. Sometimes there is, sometimes there isn't. But you just have to factor that in, and you have to address it, in the opening. And in the opening on this police case, I kind of said, look, okay, so all of us try to do something different in every case because, it's better for us. It's not as boring, whatever, or try. Doesn't mean we succeed. So in this case, I said, look, why don't I structure my opening to throw out most of the questions I think the jurors will be asking, and then discuss the actual evidence will address those questions so they kind of can feel like I didn't just shove it down their throat. I recognized their questions. So early on, and I had spoken with Dale Gallipo, who's great, and Rahul and Ben, you know him, and he does a lot of police cases. He does the really hard police cases where hardened criminals, get beat up, and he's got a civil rights case. It's a lot easier when you have a lovely 56-year-old event planner who's on her way to work and, business attire and gets horribly injured because the trooper is an idiot and didn't follow the training which she had received. But in any event, he told me, because I was going through the case with him, and the more you can go through cases with other people, including your long-suffering spouse who has to listen to cases, they ask questions, that jurors would ask. So he said, well, they're going to say, well, the police aren't doctors. I said, it's dawned on you, I'm sure, that the people who decide what really happened here, the facts, are you, not us, not the judge. You're the judges of the facts. And, it's a great responsibility. So I'm sure right now, even now, and particularly as the case goes on, some of you will start asking questions. It's only natural. You'll start to get the facts and the story. And when you hear this, I think when you hear this story, just the story, and I'm going to tell it now, and not go into any argument about it, you will think, well, that sounds terrible. That sounds wrong. But someone may say, well, someone on the jury, one of the people, and you all have to get together at the end of the case, may say, well, doctors, cops aren't doctors. How are they supposed to know this stuff? And one of you then might answer, well, there was a standard that the police had, that if you had any doubt about someone at an accident scene having an injury, you should call EMTs to the scene and they would evaluate it. And then you would learn that these events happened 5 minutes away from a comprehensive stroke center where they would have rushed her to, and all this delay and failure to call EMTs to the scene and just handcuffing her and searching her car and not finding anything that would support a finding of alcohol or drugs being involved, continued to harm her. And even if you thought, well, it's a little complicated to call EMTs to the scene, you will learn that this trooper was on a dedicated line to a dispatcher who is also the dispatcher for 911. And among the emergency cards that dispatcher had is what to do when someone has trouble speaking and one-sided weakness and is confused. And the card says, call EMTs immediately. It could be a stroke. So there were multiple. And what you're also going to learn is that state troopers are often the first responders on an accident scene. And they're actually trained in the academy on what first responders should do. And the first thing they should do is make a careful, detailed study of the driver's face, because it will tell them something about their level of consciousness. And you'll see this car camera, this trooper never did that. So I hope when someone asks that question, which would have been a good question otherwise, you will have, when you evidence this in, and I'm going to remind you this on a summation, you'll know how to answer it. There's 3 different ways she should have known this was a stroke, and she failed to use any one of them. So I mean,
I remember when you spoke about that case previously, and I first heard about it, I thought, this is about the hardest possible case you could ever have, because first of all, it's really hard to do medical malpractice cases. It's also very hard to sue the police. And you're basically doing a medical malpractice case against the police,
right?
Which is like the compounding the
that's
difficulty.
Why I became a trial lawyer. I'm a masochist, but go ahead.
But when you just explained how you discussed those issues, I thought that was really, really compelling. And actually, it framed it in my mind better than it had been before. I guess earlier on, you were mentioning that at some point in a trial, you will often answer the question for yourself, well, why did this happen? And because everything you just said explained what happened and that it shouldn't have happened, but I've yet to figure out from that story why it happened. Did you figure that out in that case? Why did that happen?
I did. By the way, there's two comments from that. Number one, this is the perfect reason why judges who grant summary judgment motions early in cases make a terrible mistake, because they never understand the case, and we don't understand the case the way it is after discovery and at the trial. But my belief, which I shared with them, and I said, you could have other beliefs. I said, well, you're going to see on the car camera footage that in the first encounter with this person on the side of the road, who, by the way, had a stroke, but had the presence of mind and skill to get herself off the road without hurting anybody else and just tapping the side fender of the road. So she took responsibility for the stroke. But you're going to hear that, and you're going to see, rather, which is always better than hearing, that for about the first 5 minutes of this encounter, Trooper Albuya got out of her car, walked over to Cheryl Ryan's car, and was relatively polite, or at least nicer than she got later on, and got some basic information. However, we know didn't make the observations she should have even then, and told her, stay in your car. I'm going to go back to my car and check your license. Then we see on the car camera footage from Trooper Albuya's car looking forward that Cheryl Rhines, who had a stroke, was confused, had difficulty even speaking, started to get out of the car. And she perched herself, first of all, on the kind of the part of the car where you step in, and was hanging on the roof by one hand, because that was the hand that wasn't weak. She almost fell out into the roadway where she could have been hit by other cars. And you'll see Trooper Albuya run up, put her hands on her, push her back in the car, and say, why did you get out of the car when I instructed you not to? And I think what you're going to see in the car camera footage is that, sadly, wrongly, the way this trooper then begins to treat this person because she disobeyed her order is as a threat or as someone who needs to learn a lesson. And she's going to arrest her. And then she decides, well, I can arrest her because, she must be on alcohol or on drugs, even though I can't smell alcohol. even though I can't do a roadside test because she's incapable of even standing. And at some point in the trial, I don't know when, I can't remember, I said, well, look, this would have been the first drunk ever who had one leg that gave out, but not the other, and who had one arm that was weak, but not the other, and who had a facial droop on one side of their face. So all she needed to do was look, and you're going to see that she never did look. And whether it was because she felt that Cheryl disrespected her by getting out of the car, and I had some African Americans on the jury, and I thought that might resonate with them, or maybe she's trying to be more macho than the men state troopers because there aren't as many women state troopers. For whatever reason, we know she made a terrible choice and stuck to it. All during this time frame, she was at the roadside 45 minutes. She could have reassessed what was going on after she searched the car and found nothing in it. And she obviously could have said, oh, well, I was wrong, but she never turned back. I also had, the hardest. So I also had a
that's sort of a confirmation bias type of approach, right? And you see that in a lot of medical malpractice cases where they early on come to a presumptive idea about what's going on, and then everything
never leave it.
They never leave it. And despite all the contrary evidence or data points that point in another direction, they just start to view everything through the prism of the original assumption, and that drives all of the decision making going downstream.
Absolutely. Yeah. By the way, while we're talking about malpractice cases, I think another thing that I've tried to use wherever the facts allow me to use it to sort of get past the respect for medical providers. Look at COVID, people were saving people's lives. Is I try to find people in the chart who did the right thing. A nurse recorded the history, which the doctor ignored. I had a case once with somebody who died during a procedure. They should have used cricoid pressure. There was some indication that he had GERDs and other issues with anesthesia. They didn't. And there were various times earlier where people, recorded the history of GERDs. And so I used them as a kind of foil to say, the nurse got it right. The intern who recorded the history, I had a case once where an intern stopped Pitocin earlier in the afternoon, and then the OB came back and started it again. So if you have one or more medical providers who you can point the jury to and say, this is what medicine is all about, they got it right. And when Dr. X, who was committed to their first diagnosis and never even looked at this history and never even considered alternatives, got it wrong, he not only let down the patient, he let down the other medical providers. They did the right thing. It should have led to the right. And I think sometimes people maybe find that, certainly a plus factor for your case. It's not just this plaintiff he let down, but it's any patient if he does the same thing. So I think.
Interestingly, on that vein, I tried a case last Friday to our pre-litigation panel, which is a part of our process, which is very unpleasant.
Which is the part I bet you hate.
I don't love it. But in that case, my associate had been working it up, and I came in and helped her try it. But what I did when I started my evaluation was I just took all of the lab data and the imaging results and the vital signs and things and put it into ChatGPT and said, hey, what are you supposed to do here? And I could tell you that if ChatGPT had been the doctor instead of the one that was there in the emergency department, the 62-year-old client would still be alive today, because in 30 seconds, ChatGPT came to exactly the right diagnosis and exactly the right course of treatment.
You get that in.
And we didn't use it in that. I'm wondering if in the future, if maybe you would be able to do that, but it just goes to the point of having a counterpoint of somebody who gets it right. And in this case, an objective, non-human AI system processing this just without any emotion, without any bias or preconception, just on the hard data of what the patient presented with and the values that got it completely right. So, but Dennis, just to wind down here because we're coming up on our hour. You've been doing this for a long time, as you pointed out, 40 plus years as a trial lawyer. For people that are starting out or just trying to figure out, navigate their way through this, give us the top 3 things you've learned that if you were starting out today, you would want to know from your present self that you could go back and tell yourself about this practice.
I'm not going to give you the top 3 things I've learned that might have caused me not to become a trial lawyer, but we'll leave that out.
Yeah. That'll be another show. Show.
Like clients sometimes are crazy, whatever. Okay, so the top 3. Okay, so all right, number 1, you have to be yourself. And each of us has, different ways we communicate. And so you can't model yourself on, Paul Revere or Don Keenan or Rick Friedman or whoever, or Ben Gideon or Rahul Ravipudi. It's got to be you. And so develop that. Read neuroscience books, read books about litigation, read a book like Made to Stick by the Heath brothers. Educate yourself in the way people think and the way people make decisions, and that's invaluable. Okay, so that's number 1. The second is that, I guess, realize that your witnesses, just like you, are all different people as well, and that you have to allow them to be them. They're not going to testify the way you would want them to testify. You just hit all the main points. They may be a little bit, but you can help them. You can say to them, look, concrete examples are always better than generalizations. Every survivor, is going to say Dad was great, but if I were telling that story, and I use this with clients sometimes, I would tell the story about, when I was a kid and down the shore with the Jersey Shore with my family, and I was standing on one of those pull down staircases you have for up in the attic where they consigned the young kids to. And I lost my balance and tripped, and I was falling head first down towards a hard kitchen floor. My father, who was at that time older, in his 60s, really wasn't that athletic. And I was stunned by, somehow realized it was happening, reached out his hand and caught my head, about a foot from the hard kitchen floor. So that's what a father, that's why if I were the survivor and I were telling the story, I would tell that story because people believe a story and a concrete example. They don't believe just a generalization. So you obviously have to prepare your witnesses. The other part of this, and this is maybe part B, is you have to realize that lay witnesses, I had a case once with where a bus driver drove a bus off the road in a snowstorm and somebody got killed and ejected. And the state trooper appeared. We didn't even have a deposition. I wasn't sure what he was going to be like. And he was like almost 7 feet tall. He was this giant guy. And he was very militaristic, and there was no way this guy was, going to get warm and cuddly. So you sort of had to, work around that and feed him things that resonated with the jury. And so the defense lawyer was stupid enough to say, well, I think this, and we always like Blanche Dubois, and the kindness in Streetcar Named Desire. We depend on the stupidity of others sometimes in trial. The defense lawyer was stupid enough to ask this big burly state trooper, well, when you got done at the scene here, you're talking about reduced speed due to conditions. Well, what did you do, when you were driving back to another place? And he looked at him, he's a big guy. He says, well, of course I drove slowly because it was snow all over the road, So, I mean, it's important to learn that you can't mold you can't mold witnesses, rather, the way you necessarily want to, but you can use their strengths in different ways. So that's it. Number 3, I guess, don't stop learning and don't stop teaching as a trial lawyer when you're actually trying a case, and try as many possible cases as you can. And that's really a problem in our business today, that there aren't enough cases being tried. Try second chair. I'll tell you one more thing. And my last 2 cases, I've searched out a young woman, trial lawyer, wannabe trial lawyer, who I think is good, and got their firms to agree that they would second chair the case with me because I don't have a big firm. And it really gives you depth of field, a second pair of eyes. And most of the time, you kind of can't resist trying to teach them. And when you teach them, you're also teaching yourself. Because in order to teach something, you have to learn it first. So, I think those are all things that are helpful. Get as much advice as you can, try as many cases as you can. I tried my first case in front of at least 10 different judges and swore that it was my first case, because we all know that even hard, crusty judges are sympathetic to young lawyers. And sometimes they ain't so sympathetic to older lawyers. So you have to use everything you can. It's a persuasion business. So anyway,
Seems like you're still enjoying yourself, Dennis.
I am. And when I stop, and that's the last thing, I get, I'm sure you probably do. And I use this analogy, the Garden of Gethsemane, story in the Bible is that Christ is, looking forward to his crucifixion, or not looking forward to it, and saying, Lord, lift this cup away from me. I don't want to go through this. Almost all of us, for every one of our cases, prior to starting and giving the summation, have a moment where we say to ourselves, why did I take this case? What was I thinking? And then we get past that, so it's good. It's good to enjoy yourself. It's good to be nervous before you go to court, so you're totally prepared. But during court, it's best if the jury also thinks you're A, enjoying yourself, and B, you're authentic. Last story, I had a case I tried with a very wooden defense lawyer, one of my favorite types, who had a notebook, and everything was in a notebook, and he's giving and he got up on his summation, and I had all kinds of PowerPoints and digital stuff to show. And there were, people on the jury who were into that stuff. This is 10 years ago. And he says, with all seriousness, but not really a lot of, belief, Mr. Donnelly had PowerPoints, but I have the power of the truth. Number one, it didn't sound like he even believed what he was saying. And number 2, it was so preposterous, it was just good. So, you can say, look, there were 2 sides to this case. One of them, us, brought you photographs, diagrams, demonstrations, illustrations, because we weren't afraid to show you what the case was really all about. The other side didn't do that so much because maybe they were afraid to show you what the case was all about. Okay, so anyway, that's...
Well, Dennis, thank you so much for doing this morning.
Okay.
I really appreciate it.
My pleasure. And next time I'll know that the dress code is more relaxed, and I'll come in normal clothes. But as I told Ben, when I first started teaching, I was so young in college that I had to wear a shirt and tie and suit, because otherwise they wouldn't know I was the teacher, that kind of thing. But
please look me up when you come to Maine.
I absolutely. I'm going to be up in June. I'll talk to you then.
It's starting to get nice.
Yeah, that's what they said. It's maybe kind of sort of getting to spring in Maine, right?
Yeah.
And that lasts 2 weeks, doesn't it?
In a month, it'll be spring. Yeah.
Okay. Well, good. I'll be there maybe in 2 or 3 weeks. I'll let you know. Okay. Take care, guys. And congratulations on the affirming verdict there, Rahul. I hope to tell you the same story years from now.
I hope so too, Dennis. I know it will happen.
Take care, guys. Talk to you.
All right, hold on, Dennis.
Now, one thing for sure, we know you're not going to be wanting to practice in New Jersey because, it's so great here.
You never told us any positives about New Jersey. You just gave 3 negatives.
Okay. Well, number one, there's good substantive law. The law on products liability. I have a case going to the Supreme Court on products liability where I think they're going to do the right thing. Actually, Rahul, your office is in it. And the law on malpractice is reasonably good, and the law on even police practice is reasonably good. I was on the jury charge committee for about 10 years, and defense lawyers started getting paid so little by malpractice carriers that they said, "Oh, I'm not doing it." So the good thing is that we have good substantive law. And, we mostly have trial judges who meet my 3-part test for who's a good judge. They like people rather than hating people. That would be number one. That's the first hurdle they have to get over.
They like Dennis.
The second hurdle, yeah, me too. The second hurdle they have to get over is they remember that they were once a lawyer, and realize this isn't easy. And the third important hurdle they have to get over is they have to let you try your case and not try your case for you. As long as a trial lawyer has those mindsets, they will make some mistakes, but we can live with them and we can work around it. Okay, guys. Good to
All
talk
right,
to you.
Dennis.
Thanks,
I will
Dennis.
Take care.
see you in August too, probably.
See you
Right?
in August.
Yep.
Okay, good. Take care.
Take care.